All right, good morning. It's wonderful to see all of you here for the start of our 17th annual Civil Justice Symposium, our Judicial Symposium on Civil Justice Issues. This is the Antonin Scalia Law School. Welcome to our law school. We're always excited when we can bring so many of you here to see this. The Law and Economics Center is celebrating its 49th year, but this is the 17th year of our Civil Justice Symposium, and I know many of you have been here before, and we have a fresh set of speakers and ideas to speak about over the next couple of days. And to those of you who have not been to our programs before, welcome, and welcome to the law school. I'm Donald Koshin. I'm the executive director of the Law and Economics Center, and we are a center here at the law school, one of several centers at the law school. We'll get a chance to tell you about some of them in our conversations in the halls, but the law school is doing great. Our dean will be here tomorrow to tell you a little bit about what's happening at the law school and introduce you to the facilities that you're in. But we're going to get started pretty quickly here with our program so that we can get going on the substance of everything. One thing that I mentioned last night, I'll mention again. I appreciate all of you being here to start right at 8. We'll be keeping on time on our schedule. If you need the schedule of the programs, it is outside. In addition, I mentioned the QR code that's on each of your programs where you can get greater or further information about all of our speakers, including extensive experience and expertise detailed in their bios. Each of our moderators have been asked to keep their intros relatively short, but it certainly does not do justice to the expertise that is being brought to bear in each of these panels. So with that, let's get started. I want to introduce our first moderator, Rowe. Lori is a judge on the Florida District Court of Appeals. She just finished a stint as being the chief judge of the Florida District Court of Appeal, First District Court of Appeal. Judge Rowe started on the bench in 2009. Prior to that, she had been in both the governor's office as well as several deputy positions in the Office of Attorney General in the state of Florida, and she received her BA from Vanderbilt as well as her MBA and JD, each from Florida State University, and has extensive experience on the bench and in civil justice issues, and will be able to lead us through our first panel with two of our seasoned panelists who have often led off this program and maybe familiar faces to many of you, but I'll let Judge Rowe do the introductions on that. So to start us off, we will look at an update on civil justice issues, and I'll turn it over to our moderator, Judge Rowe.
Thank you, Donald, and it's a pleasure to be here. Welcome, everyone. It's really, this is a joy to moderate this panel, because if you watch the video and your materials, you see that they have an excellent rapport and flow with one another, so you're going to enjoy seeing a conversation about some emerging and hot topics in civil justice. Our speakers today both appear frequently before the United States Supreme Court and the federal circuits, state Supreme Courts as well, and so we'll bring to bear that expertise. As Donald said, we're going to keep the bios extremely short and turn you to the materials, so I will just introduce to my immediate right, John Beisner. He's a partner at Skadden in Mass Torts, Insurance, and Consumer Litigation Group. He is the lead in that practice area. And we also have Bob Peck, who is the founder and president of the Center for Constitutional Litigation, and I think you're going to hear a lot from them on about 4 different topics. And so I want to just give you a roadmap of what you're going to hear, and then once we begin, they will just go back and forth in providing responses. The first topic today we will hear is about arbitration and new attitudes on the United States Supreme Court about arbitration. We'll then turn to how state contract principles affect arbitration agreements. We'll then turn to the issue of federal statutory damages cases in state courts, personal jurisdiction, and then mass torts. So we have a big slate. We'll save about 10 to 15 minutes at the end for your questions. So if you'll just reserve those toward the end of the presentation. And we'll turn to Bob to kick us off on arbitration.
But before you get started, though, I think the first topic should be what seasoned means.
Well,
Did he call us old?
I think he was calling us salty.
Oh, okay. All right. Sorry, I apologize.
All right. Well, thank you, Lori, and thank you, Donald, and the Law and Economics Center. It's a pleasure to be here with my friend John and kick off this conference as we have in the past. The first topic is arbitration, and thinking about the topic reminded me of the old Buffalo Springfield song, For What It's Worth, because there's something happening here. What it is isn't exactly clear. We've gone from a Supreme Court that reliably favored arbitration in case after case. As it said just in 2018 in Epic Systems versus Lewis, the FAA, the Federal Arbitration Act, was adopted in 1925 because of a perceived judicial hostility to arbitration. And it paved the way for the invalidation of a creatively large number of devices and formulas that state courts used to declare arbitration against public policy. What the FAA did was said that arbitration was a matter of state contract law, general contract law. If the parties agreed to arbitration through a valid contract, the agreement was enforceable except on such grounds as exist in law or equity for the revocation of a contract. So rules that were specific to arbitration were invalid, and they were preempted by the FAA. So in AT&T Mobility versus Concepcion in 2011, the FAA preempted a California judicial rule on unconscionability of class arbitration waivers. 2 years later, in American Express versus Italian Colors Restaurant, a case out of New York, the court reiterated that stance, even if the individual arbitration involved high costs that allegedly impaired effective vindication of federal statutory rights. In Kindred Nursing Homes versus Clark, the court reversed a Kentucky Supreme Court and ruled that the FAA preempted a state rule that required a power of attorney to authorize the waiver of jury trials and court access, holding that the rule disfavored arbitration. So it began to seem as if an arbitration clause trumped everything else. But a series of decisions more recently seems to say otherwise. In Lamps Plus versus Varela, 2019, the court held that a contract that provided for class arbitration could not be enforced because the agreement itself was ambiguous. In New Prime versus Olivia, also in 2019, it held that the FAA's exclusion of contracts for employment also embraced independent contractors. And then last year in Morgan versus Sundance, the court held that a waiver of arbitration, such as pursuit of a case in state court and then deciding to go ahead and compel arbitration, didn't require prejudice, that the waiver was effective regardless of the effect on the parties. And in the course of saying that, the court said, the FAA's policy favoring arbitration does not authorize federal courts to invent special arbitration-preferring procedural rules. Our frequent use of that phrase connotes something different. The policy, we have explained, is merely an acknowledgement of the FAA's commitment to overrule the judiciary's longstanding refusal to enforce arbitration agreements and to place those agreements on the same footing as other contracts. In another formulation, the policy is to make arbitration agreements as enforceable as other contracts, but not more so. So that seemed to be news to a lot of courts, because a policy favoring arbitration had been construed to give arbitration a leg up. But if you think the new trend is emerging from these recent decisions, another decision from last year also upheld an arbitration agreement despite a California rule of law prohibiting waiver of individual claims under the Private Attorney General's Act, in a case called Viking River Cruises versus Moriana. Last week, the court took another arbitration case, and this one will be interesting because it will tell us a lot about where the court is on arbitration. It's a case called Coinbase versus Susky. At issue is an ambiguous arbitration agreement. Coinbase, the cryptocurrency platform, requires users to agree to arbitration on all disputes. A delegation clause in that agreement requires users of the platform to even have whether the dispute is subject to arbitration decided by an arbitrator rather than a court. Then they decided to hold a sweepstakes, and users of their platform could enter the sweepstakes under official rules. The official rules had a form selection clause and said that the courts, federal or state, of California was the venue in which all disputes had to be decided over the sweepstakes. So a number of entries decided that they were going to sue because they thought that the rules were unfair and not as had been promised. Coinbase moved to compel arbitration. They claimed that all disputes means all disputes, including whether or not this particular dispute is subject to arbitration or not. The users claimed that, wait, this is a separate contract, a separate set of rules, there's a forum selection clause, therefore this is what applies and we ought to be able to go to court. The trial court decided that, yes, indeed, this was subject to arbitration, and the arbitrator, not the court, should decide whether arbitration should apply. But on appeal, in the Ninth Circuit, they said, no. This supersedes the previous contract. The existence rather than the scope of arbitration is at issue, and that's something that courts should decide. So now this is going before the Supreme Court. So here we have the issue of what traditional, in this case the venue being California, contract law in California means, and whether or not this addition of a forum selection clause that indicates courts essentially installs the kind of ambiguity that the court said invalidates the arbitration clause. So it's going to tell us a lot about what the court's attitude is about arbitration, and we're going to see a lot of the themes that are now in conflict play out. John.
Thank you. First of all, very much enjoy being with you again today with Bob, and thank you for moderating our discussion. I will start by agreeing with you emphatically on one thing, and that is that arbitration seems to be a topic on which the Supreme Court, I won't say is obsessed, but if you think about where arbitration fits in our overall civil justice system, and you take account of the fact that this is a court that deals with criminal issues as well, the fact that in the last several years, you go through all these cases Bob has referenced, and now this new cert grant, this is a topic that the court doesn't seem to be able to get enough of. I will agree with you that the fervor of the court in saying arbitration is the be-all and end-all here has diminished some. The chief advocate on that, I think you would say, on the court was Justice Scalia, who pressed this issue very hard, and with a different court in place now, I think I agree with you that the consistency of that sort of arbitration is paramount concept has diminished some, but I still think the court is strongly favoring arbitration as part of our adjudicatory system. And what we're seeing is, a number of instances where the court is feeling the need to clarify particularly procedural issues. And not all the cases are indicating some drawback from that position. Interestingly, last term, there was another Coinbase case on arbitration, this one addressing the issue whether if arbitration is denied in a case and that is taken up on appeal, whether the court has an obligation to stay the proceedings in the district court pending resolution of the appeal, and the Supreme Court said, yes, it must be stayed. So that, again, is an indication that the court is not throwing in the towel in any respect on arbitration. And I'd note that the new Coinbase case, Coinbase 2, as I suspect we'll be referring to it, even though it's on a entirely different topic, keep in mind that the petitioner in that case is Coinbase. They lost below. I don't know what that means statistically in terms of anything, but the fact that the court had an interest in that case suggests that it won't necessarily go the direction Bob is suggesting, although I agree with you, it's another instance where the court will be commenting on this issue. One thing I would note is that, there is some perception out there that arbitration is bad, and there are some who have expressed a lot of criticism of the court for embracing arbitration as strongly as it had. Whether it's good or bad is in the eyes of the beholder, I think, in a lot of instances, and also when you look at outcomes in cases and where a claimant succeeds or does not succeed. Again, it's a mixed bag, as is litigation generally, but the court, I think as a matter of policy, has concluded that on balance, the availability of this as an alternative process, if parties agree to it, is significant. I do want to note that I think there's a perception out there that all consumer contracts, for example, have in them now arbitration clauses. And I did want to note that I do think that a number of companies are stepping away from including arbitration clauses in their agreements. I think in some cases that's for competitive reasons. Others, it's because of the experiences that they've had with that. They've concluded that leaving matters open for arbitration. Some have adopted their own internal programs that are not exactly arbitral and are more voluntary in nature, that many consumers find preferable, and they view that as a competitive advantage, so they've sort of created their own voluntary programs to deal with concerns about products or services. So I did want to note that it's changing in terms of what the arbitration land is like out there, and that many companies are dispensing with that in favor of alternatives, and many are amending their agreements in many respects. So it's not a static environment out there.
And if I could just interject one question on that. There certainly is a role for state legislatures and Congress in, kind of balancing the consumer versus business perspective on arbitration. Are you seeing much, action on that front, and how is that affecting litigation?
There has been a few amendments to the Federal Arbitration Act coming out of Congress dealing with sexual assault issues. There is the exemption for transportation employees. But I think that, expecting Congress to do much is probably expecting too much. This is not a Congress that's capable of doing a great deal.
And I assume you're not limiting that to arbitration. Expecting Congress to do much, period.
That is correct. And at the same time, of course, the FAA as a preemptive part of the supreme law of the land under the Supremacy Clause will preempt most state legislative efforts unless it's general contract law. If it's specific to arbitration, it's going to be preempted.
Yeah, I'd agree. There's a lot of interest in the Hill on this topic. If you look at the number of hearings on it, it's a nibble arena. You see hearings on and legislation on the topics that you're talking about. Should veterans be, exempted, and those sorts of things. And there's a lot of hearings on general topics that end up being hearings on should we limit the availability of arbitration in certain circumstances. But whether there'll be a consensus at some point to actually change the law in this arena, I find doubtful at this moment anyway.
Very good.
Well, with that, I'll shift over to a related topic, and this is the topic of mass arbitration. If arbitration is enough, let's have mass arbitration. So, and I don't have a song to introduce. I don't know many songs about mass arbitration, but But it's a phenomenon that we're seeing with increasing frequency, and it's a reaction to the common use of arbitration clauses in consumer contracts in particular. And what the phenomenon is that some attorneys, plaintiffs' counsel, have been on the lookout for cases, situations, controversies that may be emerging as potential consumer class actions. And in some instances, where consumer class actions have actually been filed. And what they do is they get a recruiting program started, usually through third parties, to identify persons who may be members of the putative class on this particular topic, sign them up as individual clients, amass a large group, and then call up the defendant in the case and say, and this is literally what it is, I have 50,000 people who have retained me to initiate an arbitration proceeding on this issue against you. Now, your first reaction is these are claims that are often worth $1, $2, very small amounts. And so when you're answering that call, you're going, what? You have 50,000 people who want to pursue $2. But the reason that the call is significant to the recipient is that the company has the obligation under many of the agreements that the Supreme Court has blessed as being appropriate to immediately at that point pay arbitration fees. And at least several years ago when this process started, those fees ranged between $3,275 to around $5,000, depending on who the arbitrator was that was specified in the agreement. So in essence, what the counsel is calling to say to the defendant in that case is, you're going to have to pay when I dump all these claims in for arbitration, upwards of $250 million in fees. And if you want to work out something with me before I dump all those claims in, here's my number. And that is basically the strategy that is being used. Now, some may say, well, you've been hoisted on your own petard. You've played the arbitration game, and so, those are your just desserts. And that is out there. But the problem that is being encountered with this is that it is, in essence, a game for immediate settlement, and no one is actually proposing that these arbitrations occur. These firms that are doing this would have no capacity to take 50,000 claims separately to arbitration, which is what they're saying they plan to do when they make these calls. And so this has become a fairly common occurrence out there, and part of the problem is that once the defendant pays that amount, it's not refundable in any way. The arbitrators won't give that money back. And the AAA and other arbitration groups have been changing some of their policies to deal with this. They've sort of started a practice of volume discounts and things of this sort, but it's still, the strategy lives because of the need to pay this amount up front. And this is happening with sufficient frequency that it's become a major issue for basically any company that's got in their consumer contracts any sort of arbitration clause. One thing I wanted to note is that within the past week, the Seventh Circuit has sort of swung into action to address this issue. So there was a case involving Samsung that was facing one of these situations. They got the call, 50,000 claims had been gathered for this, and the claims were submitted for arbitration because Samsung refused to pay anything to plaintiffs' counsel. And the AAA took the position, to whom these claims were submitted, that under their revised policies, Samsung had the right to decline to pay these fees if it said to them, you may go ahead and litigate. We will not require arbitration in this circumstance. However, if you, the claimants, wish to pay a fee, and I think the fee was reduced level, you may proceed and Samsung will be obliged to go ahead into the arbitration process. Plaintiffs could have paid the fee, but they did not, and instead they went into federal court to move to compel arbitration, and the district court ordered that Samsung had to arbitrate these claims and had to pay the fees. That immediately was appealed to the Seventh Circuit, and the Seventh Circuit this past week said that it would be taking this appeal on an expedited basis, stayed the district court's order, so no arbitration will go forward, no fees are to be paid, and set a very expedited briefing schedule. The arguments in the petition, into the appeal to the circuit and the request for the stay and expedited treatment, I think get at the heart of the problem that exists here. I mean, first and foremost, it's a little unclear if the attorneys get what they demand, which is often half of whatever the fees would be, $150 million on claims that are worth a small fraction of that. Where does this money go? Because there's no court supervising that money. This is all happening extrajudicially. Not clear if that goes to the claimants, who would be getting a major windfall, whether the attorneys keep it, and so on. But there's also a concern that the process of collecting these claims is haphazard, to say the least. It is literally an effort to find names. When people have been able to peel back who these folks are, there's high percentages, and this is one of those cases, and the information in this regard was provided to the circuit, that many of the claimants don't have this product or the service. They had no relationship to them. Their claims were gathered not by attorneys, but by third parties who conducted no investigation on that. And in short, it's not clear that these claims are real. But the point is just to put a bunch of names before the arbitrator and say, these fees must be paid. And, I think this will be one of the things that the Seventh Circuit will be looking at. There are also some ethical issues that are involved in this process, because it's also emerged that to collect all of these claimants on a rapid basis, some of the counsel have been using class membership lists from other litigations. And usually there's a court order saying nobody can have access to those, but somehow access has been achieved. When the defendants have looked at the list, they've noticed a similarity to class lists in other cases. And of course, there's also the ethics issue of contacting someone to offer them your services, depending on what the ethics rules are in a state, whether that's appropriate or not, even if that conduct is occurring through a third party. So it's a very interesting response, creative response, I should say, to the use of arbitration in consumer contracts. And some may say, well, that's cheer them on, that's what they should do, but it's nonetheless become a major sticking point for a lot of companies that have arbitration clauses in their agreements. Bob?
So I'd like to talk about a different example that is currently in litigation that shows you the other side of this. New Jersey's Consumer Fraud Act prohibits certain kinds of charges that were not part of the original contract. So Verizon charges a $1.95 per month administrative fee that, alleged in this case, violates that Consumer Fraud Act. So they make millions of dollars in New Jersey each month from this administrative fee. So a lawyer representing 2,537 Verizon customers brought suit, actually brought arbitration against Verizon on this. And Verizon has a clause in its Arbitration Act. It says that when 25 or more customers raise similar claims and are represented by the same counsel, so this is their attempt to address mass arbitration, that there has to be only 10 filings within 180 days, and then after bellwether trials of those 10 occur, there can be the next 10 and such. So this would take for those 2,500 customers about 145 years to arbitrate. And so, of course, that's the complaint here. New Jersey's Superior Court and Appellate Division both agreed that this was unconscionable and therefore invalid. And now the case is pending before the New Jersey Supreme Court. A similar case is pending in the Ninth Circuit based on California's similar Consumer Fraud Act. So at least it seems like this type of a solution, one that essentially would require 145 years to vindicate, doesn't really work. And at the same time, while it may be $1.95 per month, the amount of money to Verizon is considerable, and this is why class actions originally existed, so that these small claims could be grouped together to make them viable and essentially vindicate the state law.
And this is what I was referring to as changes to a lot of arbitration arrangements that have been occurring. And, I think you're right, some may not make a lot of sense, but it's an area of considerable experimentation on the subject, but also an area that is a bit of the wild, wild west at the moment because of the use of this mass arbitration approach.
Right. There's no end to the creativity on both sides of the V in dealing with issues like this.
Okay, so we turn to the issue of statutory damages, John.
Well, this is the topic I want to address is encompasses a lot of different legal principles, and I think this all starts with the notion of standing and some of the changes that the Supreme Court has adopted in that area. But let me start by noting that there are a number of federal statutes that have in them statutory damages provisions. They're not all alike, but they basically say that if there is a violation of the provisions of the statute, a claimant may obtain as damages the greater of whatever they show as actual damages in the matter that they have sustained, or damages of X dollars, and it's sort of a minimum damages provision. And again, to be clear, the language in these statutes are different. They exist in a lot of different federal statutory regimes, but I think you find them most frequently in the financial services arena, and I could go through the acronyms, which I get lost in. There's a long list of them, but the Fair Credit Reporting Act is one that is used quite frequently, which is, as you know, governs the way in which companies are supposed to be managing credit accounts in a way that is fair to consumers. That's the point of this, and specifies certain things that they must and must not do that may affect credit reporting. And over the years, class actions have frequently been brought under these and a variety of similar statutes. In the last several years, the Supreme Court has moved into the standing arena, and it's been specifically occurring in the context of statutes like this. They've not focused on statutory damages statutes per se, but they've looked at, particularly in the consumer class action context, the question whether Article III standing exists based on the nature of the alleged injury. And they've tightened significantly those standing requirements. And so to use FCRA for an example, the court, its rulings, and I'm talking about Ramirez and Spokio in particular in this regard, presumably in the FCRA context would conclude, for example, that if a company violated a FCRA, a provision in it, it didn't properly take an action with respect to the reporting of a credit issue with respect to a claimant, but the claimant was unable to show any tangible consequences from that, couldn't show that their credit rating was reduced, couldn't show that they were denied access to loan or other financial services in that regard. It was just a violation in the air. I think under the current regime, the court would likely say there's no standing for that sort of claim. And that, of course, has caused a problem with plaintiffs' counsel bringing class actions for violation of these statutes. And basically a lot of them have been dismissed on Article III standing grounds in the wake of Ramirez and Spokio. Now, those standing decisions have ramifications in other contexts that have not been so pronounced. So, for example, in privacy cases and things of that sort, some class actions are allowed to proceed. Article III standing is found. Others, they're not. But it has had a big impact on the consumer class action arena where Article III standing is lacking. Now, historically, these statutory damages statutes that I'm referencing have been heard in federal court, because if a class action is brought and it's not brought in federal courts, instead brought in state court, the defendant almost invariably will remove that to federal court saying, this is a federal question, it involves a violation of a federal statute, and that's kind of a no-brainer that goes to federal court. But now the problem arises is if the class action is brought, the court determines there is no Article III standing, may the action then be brought in a state court that does not observe the same Article III standing requirements. And these statutes don't preserve, for the most part, exclusive jurisdiction in federal court. They can be brought in state courts. They just haven't been historically. And so there's a move now to begin bringing these cases in state court. The defendant has a challenge to remove, because particularly if the matter has been litigated, to remove it, the defendant is going to have to say, well, there's federal jurisdiction. But if it's already argued that federal jurisdiction is lacking because Article III standing is lacking, that's not going to get very far, and a defendant's going to be hesitant to make that argument to start with. So the basic news is that those of you who are state court judges may suddenly, if you have not already, begin to see class actions brought under these federal statutes that you've never seen before, because there was no reason for them to be in state court, and it's a strategy that is emerging as sort of a workaround for the absence of federal jurisdiction. There's two issues that I note in this regard. Not all states have the same standing requirements. They differ. And indeed, in reaction to Spokio and Ramirez, there are some states that have adopted, have more formally embraced Article III standing, and so those courts are not going to be a refuge for claimants in this regard. In other states, the standing requirements are less clear, but I think there's going to be a lot of focus on what are the standing requirements in state court in dealing with this issue. And so this is sort of a fair warning that those of you in state courts may see this influx of cases you've not seen before. The other thing, though, that has not been litigated, and I think will be a very interesting debate, is whether Congress intended these statutory damages, which is the motivation to bring these claims, intended them to be available where there didn't exist Article III standing. And I think, as I said earlier, it's going to depend a lot on what the language of the statute is, but if it speaks in terms of damages greater than or less than, I think that there will be defendants who will argue that, no, this claim doesn't exist in the absence of Article III standing because Congress wasn't envisioning that you would just be handing out money to someone who doesn't have an Article III type injury. We'll see how that turns out. I think it's going to be an active debate on that subject, and it may turn on language of the statute and legislative history. I think there's also going to be causation issues there because if you don't have to show that you were injured in some way or impacted in some way by the violation of FCRA, I don't know what prevents anybody from coming in and saying, well, I get some statutory damages here, if you're sort of doing away with that causal connection to some extent. So I raise this as an issue that I think will get a lot of discussion going forward. And since this, I think, is a process, it's just beginning, we don't have answers to offer on that. Although Bob might have all the answers, I don't know.
Well, this discussion took a direction that I had not expected, but let's start with a little history. The Constitution establishes only one court, the Supreme Court, and allows Congress to establish such other federal courts as it deems necessary. So, in the beginning, the anticipation was that state courts would have to hear federal cases. And in fact, while we have the anti-commandeering theory that says that the federal government can't assign the executive or legislative branches of state government any responsibilities, there is the Judges Clause that allows the federal government to assign responsibilities to state courts. And so as a result, the anti-commandeering theory doesn't apply to state courts. So as a result, we have a number of statutes that look to exclusive state jurisdiction to vindicate federal rights in certain circumstances. Magnuson-Moss Warranty Act, for example, assigns to state courts those individual warranty claims under the Act unless there's a certain number of named plaintiffs. You can't do it as a class action. You have to do it as named plaintiffs, or a certain amount of money in dispute, and then it can go to federal court. So the idea that there are federal statutes that have to be enforced in state court, it's not an unusual one, and it's one that has been recognized throughout the history of the country. At the same time, the Supreme Court, in a decision written by Justice Kennedy called Orozco, recognized that the case or controversy provision in the Constitution that essentially means strict standing in the federal courts does not apply and is not often in state constitutions, and so therefore state constitutions can have far more liberal standing doctrine, and many do, well established under state constitutions. In addition, of course, state courts are common law courts in the way that federal courts are not, so they have broader equity jurisdiction as well to sort of vindicate and assure that there are remedies for certain kinds of things. So when Congress passes a statute that has statutory damages, it's basically serving several purposes. It's recognizing that it's encouraging plaintiffs to vindicate their rights, especially when damages are too small or difficult to quantify, just as when a contract has liquidated damages. They serve to expedite lawsuits because the damages element need not be proven. And they also serve a punitive purpose. They make sure that federal law is being observed, essentially encouraging the equivalent of private attorney generals. So it's not a surprise to me that if the federal courts are turning a blind eye to some of these cases, that they are then arriving in state court for the vindication of clear rights established by federal law.
And just one final comment on this. Bob, I think I agree with you. I don't think the debate on this is going to be whether the state courts are empowered to hear these claims. I think the battle is going to be over state standing requirements and whether a particular case meets those, whatever they may be. But secondly, the statutory interpretation issue. I think that's where the battleground is going to be. And oddly, so you may get a lot of state Supreme Court decisions saying what FCRA means, which will be an interesting development, and then perhaps the Supreme Court ultimately weighing in on this issue, interpreting state Supreme Court interpretations of federal statutes.
Right.
So it's a,
Right.
we've certainly, I mean, that's certainly been seen before.
Right. It's definitely interesting because what you will have is, of course, state courts interpreting federal law. They do not have to follow what the lower federal courts, the district courts or the Court of Appeals say about that, but they are subject to review should cert be granted by the U.S. Supreme Court, and then that would be mandatory upon them.
And just one follow-up question there. Do you expect in that context to see a lot of state counterpart of the federal statutes to be brought in the state court as well, along with interpreting that federal statutory right to damages?
I think that this development will encourage state legislatures to do that. We saw the same thing with the mini FTC acts, and I would expect that similar kinds of laws would be popular in at least some states.
Right, and I think there certainly are already many, and so that's one of the things I think that we could probably look to for the state court judges in the audience. Okay, I think we have time to turn to personal jurisdiction for a few minutes.
All right. Although I could use the same Buffalo Springfield song to introduce this, I'm going to simply use the lyrics of "You can't always get what you want." Personal jurisdiction has had a roller coaster type of existence in the Supreme Court. And that roller coaster basically focuses on how state courts exercise personal jurisdiction. The leading case, at least for a while, was Bristol-Myers Squibb versus Superior Court, a 2017 decision in which the Supreme Court capped off a decade of decisions denying personal jurisdiction to state courts because of a function of federalism, basically saying that because another state has a real interest here that is only attenuated in your state, you do not have personal jurisdiction, and the exercise of it would violate due process. So in that case, it was a prescription drug. People filed in California because, first of all, the drug was distributed by a California company in California, but also because Bristol-Myers had substantial amount of distribution in California where it was used and caused injuries. What the Supreme Court basically said is that, yeah, the California plaintiffs could move forward with it, but the plaintiffs from other states, such as Texas, for example, could sue McKinney, the co-defendant in California, but would have to vindicate their rights in Texas on their own injuries against Bristol-Myers. And so they said that, you know, this is still consistent with International Shoe, the seminal case on personal jurisdiction that made fair play and substantial justice to be the talisman for whether jurisdiction exists. Then in Ford versus Montana 8th Judicial District Court, the court found that there was no due process violation when courts in consolidated cases in Michigan and Montana exercised jurisdiction over vehicle crashes on their roads against the manufacturer. Even though in both instances the cars were purchased used in a different state, or the original purchase was in a different state, and Ford argued that either the state where the original purchase occurred had to be the venue, or the place of manufacture, or under general jurisdiction, its headquarters or incorporated state. But the Supreme Court found that Ford had a substantial presence in both states, sold these vehicles, serviced these vehicles, and because the injuries occurred in that state, these were, again, product liability cases in which there were failures by the car that caused either death or injury. And as a result, the interests of these states where the incident occurred was sufficient to vindicate due process. So at this point, it seemed like the first time the Supreme Court was pulling back on this almost crusade of finding personal jurisdiction lacking unless everything occurred in that state. So one interesting way that this is played out in state court is in a decision earlier this year in the Massachusetts Supreme Judicial Court. In a case called Dowsett versus FCA, the plaintiff was injured in a 2004 Chrysler Sebring in New Hampshire due to failures of the car structure. She filed suit in New Hampshire, where she was injured, and Chrysler removed it to federal court and then moved to dismiss on personal jurisdiction grounds. That motion to dismiss was granted and took place before the Ford decision was rendered. The plaintiff then went ahead and refiled in Massachusetts. It was within the statute of limitations. Ford comes down, and now Chrysler argues that the accident didn't occur here. It should have been filed in New Hampshire. And so originally, the first court said, yes, you're right, and dismisses. Goes up to the Massachusetts Supreme Judicial Court. And there they basically said, I'm sorry, it was moved again to federal district court. Federal district court agreed, but then the plaintiff brought suit in the state court, and now Ford argued that Massachusetts had no interest in this case, and therefore it should be. And the U.S. Supreme Court has rejected in Ford that there needs to be a causation element to having personal jurisdiction. Nonetheless, the Massachusetts Supreme Judicial Court said, but for Chrysler's extensive business transactions in Massachusetts, which included distributing this Sebring through the Massachusetts dealership, Doucette would not have been injured in New Hampshire, making the FCA, that's Chrysler's corporate name, distribution in Massachusetts the first step in a train of events that results in personal injury. That satisfies the Massachusetts long-arm statute, and it satisfies due process. So what we're seeing now is at least the state courts basically reclaiming a jurisprudence that might have been questionable under Bristol-Myers, finding that it's again valid under Ford. I would have argued also that, there was judicial estoppel here because the fact that Chrysler said, bring it in Massachusetts, not in New Hampshire, and then when we got to Massachusetts saying, bring it in New Hampshire, that should have been enough, but the decision goes much further than that.
Well, on this point, I'm not sure that, I agree with you, the Ford decision by the Supreme Court tempers, if you will, to some extent, the Bristol-Myers ruling, but I still think the court is embracing the principle that there needs to be a nexus. There's some fuzziness about what it is between the forum and the claim that is being brought. Bob, I thought you might get into the Mallory decision from the last term of the court, but I think I'm not sure how pervasive the impact of that decision will be. Basically, in Mallory, the court dealt with a statute in Pennsylvania that says that when a company registers to do business in the state, which is required if you want to do business in the state, you are waiving basically your personal jurisdiction arguments in Pennsylvania. So in other words, by doing business here, you by waiver under statute are agreeing you may be sued here for anything irrespective of principles of personal jurisdiction. And the court, based on a very old decision that had addressed this issue in the view of the majority of the court, said, yes, that statute may be observed. And I'm not sure, though, how broad an impact that's going to have, because as things have evolved, not that many states any longer have statutes like that. We'll see if any states respond by adopting them, but I'm not sure they will because of the potential impact that would have on the volume in their respective state courts. What I find interesting, though, in the Mallory decision is how the majority and the justices who were not part of the majority on this issue were very concerned that the Pennsylvania Supreme Court had not addressed the Dormant Commerce Clause issue that had been raised below, but wasn't before the Supreme Court because the Pennsylvania Supreme Court hadn't embraced it. And so I'm not sure that's going to be the final chapter there, but to your point, I think what the court is concerned about, and this was an issue that was very important to Justice Ginsburg during her time on the court, who I viewed as the real thought leader on this issue, is the need to sort of have litigation be filed in forums that have some nexus to the claim. And a concern, as was quite explicitly addressed in Bristol-Myers, about forum shopping. And the concern that was growing at that time that there were certain cases, certain states that were drawing mass tort claims in particular. Thousands of claims were being brought in by persons who were not residents of that state regarding injuries that didn't occur in that state and had really no relationship to the forum. That's really what was going on in Bristol-Myers and the growth of claims in that particular case in California. And I don't think the court has walked away from that concern. You know, Justice Alito, in his concurring opinion in Mallory, just basically says, I really think there's a problem with the statute under the Dormant Commerce Clause because, as he put it, the burdening of interstate commerce to the detriment of other states that occurs if this is commonplace. And 4 justices in dissent lamented the fact that the Dormant Commerce Clause issue was not before the court. And so I think if this is presented again out of Pennsylvania or some other jurisdiction with the statute, we may see a different result. And I see the court in these statements clearly grasping this notion that there needs to be a nexus there. I agree with you, there's some fuzziness in the wake of Ford about what exactly that is, but I do think there's a great hesitancy to sort of cut loose and say any state court can hear any claim that essentially arises anywhere. There's got to be some nexus there.
Yeah, I agree that Ford stands for the proposition that if the injury occurs in that state and the business does substantial business there, that is sufficient to meet due process. And in Mallory, they found no due process violation because the statute, which had been on the books forever, gave every business notice, the due process requirement of notice, that they would be subject to general jurisdiction by doing business there. Now, at the same time, I agree with John that this is not the final chapter on Mallory, which is one of the reasons why I didn't cover it. It's because I do think it is vulnerable to the dormant Commerce Clause.
Let me just note one final thought of this subject, and that is that I do think if, as a result of Mallory, you see some jurisdictions, Pennsylvania or one of the others that has this sort of statute, suddenly become a magnet for large numbers of mass tort claims, as we saw pre-Bristol-Myers in California, you then have sort of the situation that gave rise to CAFA and the concern that certain state courts were sort of dominating the field in this area. And there's at least one federal judge has put the proposal out there, irrespective of this development, but this would give fuel to it, that the federal multi-district litigation statute should be amended such that if an MDL proceeding is created to address a group of claims as defined by the judicial panel on multi-district litigation, federal jurisdiction should be, by statute, provided to have all of those cases be in federal court so you can have them all in one place. Don't know how much interest there would be in that, but given that ultimately CAFA was passed on those grounds, that's a statutory response that at least would be out there, although I suspect that the Supreme Court would inject itself in this situation before it ever got to that juncture.
Very good. Well, we have about 13 minutes remaining, so we have time maybe for a lightning round on mass torts, maybe a couple minutes each on a topic you'd like to educate our audience on.
One topic that I wanted to mention that's been much in the news recently, and this does come out of the mass tort context, is a growing concern, and I alluded to this earlier when we were talking about mass arbitration as well, about the adequacy of investigation of claims in these mass litigation contexts before they are filed. And I want to be very clear about something. There are many of those who practice opposite me in the plaintiff's bar who I admire for the amount of work they do in developing their claims. You sit down to negotiate a settlement with them and they wheel in 15 boxes, and whatever question you ask, they'll go to the box, even though they've got 1,000 claims they're dealing with, and answer your questions. And so I have great admiration for the preparation. But there are others who operate under a different business model where you don't spend a lot of time looking at the details of 1,000 claims, and that is becoming an increasing problem in mass tort proceedings. And I'll note two places where this has arisen. The Federal Court's Advisory Committee on Civil Rules is looking at the moment at adopting a new Rule 16.1. And the reason there's a .1 on there is it's kind of a a rule that would apply specially in mass tort proceedings. So it's not generally applicable. So you put that point one on there to say this is for particular kinds of cases. And this is one of the subjects they're addressing, is how to address, how do you encourage counsel through the effect of the rules to do that due diligence before they file a claim? How can those claims be tested? And they've asked general public, but defendants in particular, to provide information on where they believe there is evidence where that sort of investigation has not occurred. And usually where you find this, find evidence of this, is you negotiate a global settlement of a controversy, assuming that there are 60,000, just pulling that number out of the air, claims in the dispute, and the money is there, and you tell people to come get the money, and they basically, all they have to do is show exposure to whatever risk is involved, such as taking the pharmaceutical product at issue, and B, that they sustain an injury. Give us a medical record that shows that whatever you alleged happened when you took this product happened to you. And in a lot of these proceedings, upwards of 30-40% don't show up to collect the money. And given that there's money on the table and they have a lawyer, one presumably would think they would show up if they actually had experienced a problem with the product and had sustained injury. And so you're kind of shaking your head because you've negotiated this settlement on the assumption that all these claims are out there and the number is actually half, and so a lot more money technically has been paid. There's usually a way to claw that back, but it's a headache because it would have been easier to have settled that case a long time ago if you knew there weren't that many claimants. And so that's one place where this has arisen. The other thing I will note is that the House Oversight Committee about a month ago had a hearing on this subject. Now, let me pause for a moment and say what a hearing is before any congressional committee, particularly on the House side at the moment. It's a loose statement. So this hearing went for 3 hours. I think about 20 minutes of it was actually spent on this topic. The rest was one side, I won't say which, was raising questions about the ethics of Supreme Court justices, and the other was talking about impeachment during the hearing. So it was your normal grab bag congressional hearing. But to the extent that it was actually on this subject, what emerged were concerns that, and I won't get into this in detail because there are other panels on this, that litigation funders, particularly hedge funds, have come up with this business model of just collecting claims without much intention of litigating them, which has the effect I was just talking about of causing a distortion in efforts to try to settle those cases. There's actually delaying resolution, and I'll leave it at that.
So, John, we're not here to fix congressional dysfunction. But
We don't have enough time.
yes.
Not in 2 minutes.
But I will point out that MDL's multi-district litigation courts now dominate the federal docket. Originally, they were intended to help facilitate common procedural issues and then send the cases back. What they've developed into are ways to make sure that there are settlements. And so it's moved very far from that intentional function. And so I was involved in one city's claims under opioids that was assigned to the Northern District of Ohio. We moved because we did not sue any out-of-state people. We didn't make any claims that allowed for federal jurisdiction. We moved to remand at every possible stage. It was never, ever ruled upon. Instead, we were asked for fact sheets. We were asked for all kinds of things in order to facilitate the settlement. And when the settlement finally came down, it just didn't make sense to continue to press for removal, even though our motion was now 4 years old and still never ruled upon. So there are lots of issues with MDLs, and I just think that what we're talking about with respect to the rules and everything barely scratches the surface.
And maybe we can get into that during the breaks today. I want to leave 5 minutes for the audience. We have microphones on either side if you'd like to come to those so that everyone can hear your question. If you will do that.
I have a question I'd like to address to Bob. Bob, of course, with your Center for Constitutional Litigation, Bob, with your Center for Constitutional Litigation, you're in a very unique perch to see the election litigation that's going on across the country, particularly back in 2020. But I know in 2024 we could have a very close election, and I'm curious, how do you see that the state and federal courts are prepared for the possible flood of electoral litigation that may be on the horizon?
I have no doubt that we are going to see a flood that will cause what we've seen to date to pale by comparison. That claims, whether valid or not, are going to proliferate. We're going to see actions filed in state and federal court that will be at cross purposes and with no real mechanism to coordinate. And I think that the amount of litigation is going to overwhelm the system. These are not the kinds of cases that courts are well set up to deal with in the first place. And I also think that both timing, requiring expeditious hearings and decisions are going to be extraordinarily difficult. We're going to see that happen prior to Election Day as well as after Election Day. And, back in the 1980s, I was invited to go work on a project with the Supreme Court of India because they had a 10-year backlog of cases. And we're basically struggling under it, not knowing what to do. And although there were some simple solutions, such as the fact that they didn't have briefs, and so therefore during oral argument they would actually pull books off the shelves when someone mentioned a case and read it on the spot, that arguments could go on for weeks, harking back to Daniel Webster. The fact of the matter is that was not a justice system, and I have fears about our ability to respond.
I think we have time for one more question. And, sir?
Gentlemen, would you say a few words about the roles of provisions for attorney's fees and multiples of damages in initiating or sustaining litigation in your observation or experience?
Obviously, these are designed to be incentives for plaintiffs to vindicate rights. Where it's provided by statute, I think that courts have no choice but to apply it and make use of it. I think that it primarily involves areas where it is difficult to bring cases. It's difficult to vindicate those cases. But I think that they're also essential because there's no other way those cases could be brought.
I do think that from a policy standpoint, all of us, and I include both plaintiffs and defense counsel in this, need to step back and think about whether the litigants, the plaintiffs in the system, are being well served by a lot of what we do. It hasn't received a lot of attention, but there's a settlement that was announced recently in the earplug litigation that involves many veterans in a federal MDL proceeding. And a comment was made in one of the hearings that the objective was that at least half of the $6 billion settlement in that case would reach the claimants. And I was like, whoa, wait a minute. Where's the other? So that's $3 billion that has been paid to address these injuries that isn't getting to the claimants. Where is that going? And how do we justify that? There's a lot of litigation funding in that case. I don't know, if it's going there and so on. And then you look at how much money was spent, and I don't mean to focus on that particular case, but in any others, how much defendants are spending, and you just kind of go, is this whole thing revolve around those of us who are attorneys, and how much of this is really focused anymore on claimants, as they would refer to themselves as victims in these circumstances? And I do think, as a policy matter, we need to step back and be thinking further about that. And I'm aiming this at both sides, because there are excesses.
Although my experience earlier this year with one case in which attorney fees were being awarded, although the court approved my hourly fee, it reduced my fee by 82%, meaning that I got the value of 1.5 hours of work on that 5-year effort. It happens both directions.
Well,
Yeah.
and I'll have to have you continue that and bring those economic principles to bear during the break. But our time is up for now. We thank you both for your insights and sharing your expertise with us this morning. Thank you.
Thank you, Bob and John, and thank you, Judge Rowe, for moderating the panel. I neglected to mention earlier that thanks are also due to Judge Rowe for being part of our Judicial Advisory Board for the Judicial Education Program here at the Law and Economics Center. We value very much the advice that we get from our board. We value the advice that we get from you. So throughout the program, please do let us know how things are going and give us your ideas for how they can improve or what should be sustained. But one of the things that we hope to sustain is a 15-minute break in between each of these. So please, we'll see you back here at